Miscellaneous. Which one of the following statement is not correct? 1 and 4 is not correct. Which one is correct are: a stranger to the contract can sue in the both English and Indian law. Consideration can move from promissory alone in the English and Indian law. When a man advertised that he he has a stock of book to sell, he is making an invitation to offer. Satyabrat Ghosh versus Bangni Ram, frustration of contract. West Bengal Financial Corporation versus Glucose Race, anticipatory breach of contract. Union of India versus Steel Authority of India, unjust benefit under the mistake. Salima Jabin versus National Insurance Corporation, no version. Which is correct? Proposal plus acceptance is equal to promise. Promise plus consideration is equal to agreement. Agreement plus enforceability is contract. A contract is stand discharged by performance of contract, frustration of contract. Novotion. Consens ad idem means meeting of minds. Past consideration is valid in India only. On which one of the following ground a party to the contract cannot be discharged by performing it? Commercial hardship. A contract counter offer is a rejection of the original offer. Under the Contract Act, consideration may proceed from promisee from a person other than the promisee. When a good are displayed in a shop window, the price tag attached to them, the offer come for the customer. A unilateral contract in which one party is bound is also known as executed contract. Inadequacy in the consideration is relevant in determining the question of free consent. The word not defined in the specific relief act shall understood accordance to the Indian Contract Act. Discharge of contract can happen with frustration, performance of contract, impossibilities. Display of good in the shopping mall is an invitation to offer. The defense of non-est factum is available to a contracting party who has committed mistaken as to the nature of contract, unless it is specifically provided in the contract of sale. Which one of the following will not regarded as essential of the contract? Stipulation as to time of payment. Who said acceptance of offer with a lighted matchstick in the train of a gunpowder? Sir William Anson. We consider the following statement with regard to Uberium fidei and find out which one of them is correct. It fall within the classes of classes which require to utmost good faith. Every contract is contract. Ubimeri fidei is wrong. Contract of insurance is example of Ubimeri fidei. Which one of the following pair is correctly matched? Section 29. Agreement void for uncertainty. A bookseller advertised that he has a stock of book to sell. He is making an invitation to offer. A standard form of contract is also known as contract of adhesion, unilateral contract. A own B 3000 rupees. C paid to B 2000 rupees. B accept is satisfaction of the claim against A. The payment is in the discharge of entire claim. The contract uberium fide means contract of utmost good faith. Quantum merit means proportional earning. Which country does not recognize the past consideration? UK. Announcement of reward to a general public through newspaper to find stolen good is an offer. Ghansam and Afzal are good friends. They are traders and together keep on doing business transaction very often. In April 2016, they entered in a contract. Afzal has a certain confidential information from his private source about some change in the price which affect Ghansam's willingness to proceed with the contract. As per the contract of 1872, indemnify which one of the following is applicable. Afzal is not bound to inform Ghansam about the change in the price. The leading case of Harvey versus Fessy related to which one of the following? Invitation to offer. Novotion section 62, unjust enrichment section 70, party competent to contract section 11, disposes of the property induced by threat cause death section 15. Tender is invitation to an offer. A notice in the newspaper inviting traders is an invitation to the proposal. Lalman Shukla versus Gauri Dutt general offer. Tweedle versus Atkinson privity of contract. Balfour versus Balfour intention to contract. Khan Gul versus Lakha Singh restitution. Nash versus Inman necessary. Carlyle versus Carbolic Smokeball Company court ruled that the offer need not to be made to the ascertained person. The theory of quasi-contractual obligation is based to prevent unjust enrichment. Who is considered to be the real founder of the theory? Lord Mansfield. Some part of the law of tort have been codified by statutes relating to particular branch of law. One of the statutes is Indian Contract Act. The proposal has been accepted subject of certain condition. Then contract is not constituted at all. The Carlyle versus Carbolic Smokeball Company define wagering agreement with Justice Hawkins. Invitation to offer. Harley versus Fessy. Anticipatory breach. Hostler versus De La Tour. Restitution. Leslie Limited versus Sally. Implied contract. Upton Rural District Council versus Pauli. Which one of the following cases is related to cross offer? Teen versus Hoffman. Which one of the following is not essential for contract, does not find a place in Indian Contract Act? Intention to contract. Restitution stop with repayment begin. Where repayment begin is the principle of which is correctly based against the minors only. Contract can be discharged by frustration of contract by performance of contract. Novation of contract means substitution of new contract in the place of original contract. Bank guarantee in the independent contract between bank and beneficiary. Ratification of an act can either explicitly or impliedly. Which one of the following statement regarding consideration is not correct? D. Which which is stranger to it cannot see it. Which one is correct? Are it must be given at the desire of the promissory. It may be passed also. It is not adequate to the promise. For the acceptance, mere mental resolve to accept would not be sufficient. There must be an external manifestation of the intent by speech, writing, or other act. Bhagwan Das, it was held by Supreme Court Bhagwan Das versus Girdhari Lal. Difference between contract and social agreement is that intention to create legal relationship. Satyabrat Ghosh versus Mangni Madan, doctrine of frustration. Raj Rani versus Prem Adib. Raj Rani versus Prem Adib, minors agreement. Intros Limited versus Mile East Corporation is communication to acceptance. Harley versus Facey is related to invitation to offer. A stranger to contract cannot enforce the contract. He is not a party to the contract and cannot take benefit. A railway timetable is a general offer. A public notification to the tender is an invitation to offer. Picking up the article for sales and putting them in the basket in the self-service mall is not an accepted of an offer. A say to B that A is an offer and not accepted. B should say no immediately. B keeps silent. Is acceptance of an offer. A see that child of B is drowning in water. A save a child from drowning in water. B promises to give him 25,000. In the context of which one of the following preposition is correct? B is liable because the agreement is non nudum pactum. The display of article in showroom indicating the price of amount is invitation to offer. A sent his servant to B to trace his lost nephew. When the servant has left, A announced a reward of 5,501 rupees to anyone who traced the boy. B found the boy and brought him home. Then came to know about the reward. Under Indian Contract Act, can claim the reward? No, because he did not know about the offer when he found the missing boy. Under the Indian Contract Act, the publication of notice of the invitation tender is notice inviting proposal. Doctrine of privity of contract means only party to the contract can sue and sued upon the contract. Which one of the following statement is incorrect? A party inviting tender in 18-year-old accept the tender. The rule laid down in the Adam versus Linsell was approved by the House of Lords in the Dunlop versus Higgins. Under Indian law, the contract consens and Adam means to agree on the same thing in the same sense. Match. Counter proposal, head versus bench. Damage for the breach. AKAS Jamal versus Mullah Daud. Acceptance by conduct. Hindustan Corporation Insurance Society versus Syam Sundar. Commercial hardship. Gyan Saran versus Ram Charan Ram Gopal. A contract or telephone became competent at a place where the acceptance is heard, in which case it was held. Bhagwan Das versus Girdhari Lal. A lent rupee 1 lakh to B and B promised to repay it with interest of 12% per annum after 1 year. The agreement is also provided that amount is repaid within 6 months at the rate of 10%. The stipulation is valid. The A entered into contract with B to sell him 100 ball of cotton and afterward discovered that B was acting as an agent for C. The price of cotton A may be only against C. Under Indian Contract Act, good display in the shop of a window with price label will amount to an invitation to offer. Acceptance by conduct. Bhagwan Das Prasad Pawan Kumar versus Union of India. Pushing. National Association of Software S Company versus Ajay Sood. Contract through email. Promissory estoppel. Contract through email is Ali Muhammad Sheikh versus J&K. Promissory estoppel. Sapna. Contract through email is Sapna Ganguly versus R Enterprises. The promissory estoppel is Muhammad Sheikh versus JK and Company. Compromise of the dispute claim is a good consideration of the contract. The concept that says unfair, unconscientious contract and usually should not enforce is known as Kuppa in the contract Hendo. A suit for money paid and received does not lie in the following set of circumstances: money paid to the plaintiff to a third party for the benefit of defendant which is plaintiff seek to recover. Which one of the following combination is correctly matched? Responsibility of finder of goods 71, COT liability 128, sub-agent 191. MG George versus MG George. Intention to contract. Weeks versus Tabald. General proposal. Henson versus Stevenson. Reasonable notice. Curie versus Misa. Consideration. In which one of the following instances the discharge of agreement has not been effected? A. Await arrival to B to finish the painting for B. Super evening frustration. Super evening for impossibility, frustration. Consideration. Quid pro quo. Good faith. Uberium Fedis contract. Dunlop Tire versus Sigford and Company. Privity of contract. Cardler versus Carboli. Crawford at large. Fishers versus Built-in. Invitation to treat. Teen versus Hoffman. Cross offer. Harley versus Filsey. Question of price. A tender is invitation to the proposal. Which one of the following statement is correct? A claim for damage arising out of breach of conduct is not debt. A person who enters into a contract with the government does not necessarily thereby undertake a public duty. Correct sequence. Offer, acceptance, consideration, agreement. Tender is the invitation to offer, which is the terminology used to describe the situation of two parties make identical offer to each them in ignorance of the other of cross offer. In the formation of contract, which is not a three essential: damage, an advertisement of auction is invitation to offer. A agree to pay B a sum of money if B get married to C, C marry D. In such situation, which one of the following statement is correct? Performance of agreement will be deemed impossible. A person cannot be revealed from contract which he is no unlawful contract. Doctrine of illegality. Case of general offer, there is no need to communicate an acceptance if not required by the proposer. This has been held by Carlyle versus Carbolic Smoke Ball Company. What is a reasonable time for the performance of contract is a question of fact. Executory consideration is consist of promise in future liable of outstanding on the both party is a promise for promisee. On the approval tender, the concluded contract arises immediately. Contract has to set three essential. Which one of the following is not an essential element of formation of contract? Promise. Good displays in the showcase of a shop with price tag is invitation to offer. Correct. Which one is correct? Proposal plus acceptance, promise plus consideration, agreement versus plus enforceability, contract. Which one of the following contract means privity of the contract? Only party to the contract can sue. In which one of the following cases related to general offer? Lalman Sukha versus Gaudi Dutt, Carlyle versus Carbolic Smoke Ball Company. Who said an offer need not to be made to a certain person, but to contract can arises until it has been accepted by a certain person. Anson. Arrange the following concepts. Offer is communicated, offer is rejected, counter offer is made, counter offer is accepted. A tender is invitation to offer. The valid contract is essential stage cease to be enforceability of subsequent due the intervention and unforeseen factor. The contract will become void since the time ceased to be enforceable. A agreed to sell a horse worth rupees 5,000 for 1,000. The consent of agreement freely given. The agreement is a contract. Arranged in the sequences: invitation to offer, communication of acceptance, deceit, damage.